Senator Culleton.
Mr President, just one question.
Order on both sides.
To the Senator, the Honourable George Brandis.
Just a moment. Order on both sides. Senator Culleton, start again.
Thank you, Mr President. One question to the Senator, the Honourable George Brandis, QC, Attorney-General and Leader of the Government in the Senate. Since Senate School, it has come to my attention that there is a discrepancy between Section 33 of the High Court Act 1979, which says that all process shall, which must be issued in the name of the Queen, and the High Court rules of 2004. If this appears to be the case, why has the High Court felt free to defy the Parliament for 12 years?
The Leader of the Government in the Senate, the Attorney-General, Senator Brandis.
Well, thank you. Thank you, Senator Culleton. Congratulations on your inaugural question in this chamber. I must confess, Senator Culleton, I wasn't expecting to be asked about the High Court rules. An object of some fascination to me, I might say.
On my left.
I will have a look at Section 33 of the High Court Act and whether or not it is apparent that there is an inconsistency, as you say, between Section 33 of the Act and the rules made under the High Court Act. As you would be aware, Senator Culleton, the rules of court are procedural rules. They attach forms, usually, that are used in the process of the court and the various procedural steps in proceedings before the court. I must confess it's never been drawn to my attention before that there may be an issue about the consistency between the High Court rules and Section 33 of the Act, but as I say, I'll look at the matter.
Thank you, Attorney-General. No supplementary, Senator Culleton. Thank you, Minister. Senator Brandis.
Thank you, Mr President. I ask that further questions be placed on notice. Mr President, I have some further information in response to a question asked of me on Monday by Senator Culleton. Senator Culleton, in his question to me on Monday, pointed to what he said was an apparent discrepancy between the requirement in Section 33 of the High Court of Australia Act that all process shall be issued in the name of the Queen and the High Court Rules 2004. I undertook to have a look at the issue, and I did. And through having looked at the issue, through my department, I drew the matter to the attention of the Principal Registrar of the High Court, Mr Andrew Phelan. Mr Phelan has responded, and he has advised that the High Court's Rules Committee wants to have a look at the question, and that will probably take place at the next meeting of the High Court's Rules Committee in October. If I may say so, Senator Culleton, it is very, very unusual, if not unprecedented, for a senator's question to find its way onto the agenda of the Rules Committee of the High Court of Australia. And I'm sure it is utterly unprecedented for a senator's inaugural question to do so. Thank you, Senator Culleton.
Thank you, Senator Brandis.